Are you a general contractor or an owner directly hiring subcontractors? Watch this video to learn exactly what to include on your next job to avoid a costly lawsuit. Hi, Ron from Ronald Rohde Law. We're a flat fee law firm based in Dallas, Texas. We help contractors and tradesmen all over the state. We specialize in contract formation, LLC creation, and everything you need to run and expand your business in a safe and efficient manner. We do this all for a flat rate. Schedule a free consultation at the link below. While everyone has been busier than ever, you should always make time to review and update your legal contracts. With the increase of new subcontractors and inexperienced investors all over the place, it's important to protect yourself in the event of a breach, and that's a material failing on one side or the other. This video is going to outline 5 clauses to put in your next contract to ensure you avoid a costly lawsuit. Number 1, identify the parties. We are not working with DBAs, sole proprietors, or individuals who may or may not be performing the work. You want to correctly identify the owner either as the entity or a husband and wife, and to ensure that you could file a lien later on that later, as well as the LLC or another entity. This is critical to ensuring recourse in the event of a dispute. Number 2, detail the scope of work. I guarantee you that the scope of work would be more detailed if you knew you were going to be in a lawsuit. Therefore, spend the time up front to really clarify what you're doing for this job. Does it include moving this post? Does it include reaffixing the original materials? Does it include an owner-purchased accessory or a fixture that may not have been in your original scope and you don't intend to reinstall something else that the owner purchased? Adding details ensures both parties are on the same page for the job. And while it may seem like a waste of time, for standard jobs, you should be able to reuse the same section, right? We call this your boilerplate contract. And for example, if you do fence construction, what is the standard post spacing? On every job, you should be able to consistently post the words that describe exactly how you do it. Do you put stringers on your gate? What type of latch are you using as the default? Just copy and paste that language, but be very, very clear about what type of concrete you're putting down. How deep are you going to dig the hole? What type of material for the post, type of wood, diameter of the metal poles. All these little details, but can cause a big dispute if somebody is expecting X and the product is delivered as Y. If the contract just says metal poles, neither party is right and both parties lose, and the only people that win are the lawyers. So, number 3, fees. This is another area that you cannot be too detailed. Specify exactly when a payment is due. How is it due? What's the judgment process? Beyond not paying for materials, what happens if you purchase custom materials? What if you order and deliver on the job site? There's all sorts of different triggers beyond just a 50% upfront and 50% upon completion. What does that mean? You've got to really dig into the details and figure out when should you get paid and when do you have an obligation to pay. Number 4, a notice for cure. And this is a pretty generous one, but it puts it explicitly in there where if one side is really unhappy with the way a job is progressing, they can send a notice that the other side is materially breaching their agreement. And then that gives them maybe 7, 10, or 15 days, depending on the type, depending on the trade, and how big the project is, that the other side has to fix it. They need to cure their behavior, otherwise they're going to be in breach. This is a legal written notice sent to the other side, and it's a good clause for both parties to understand a intermediate but also very formal step that you're not happy with the contract. Number 5, attorney's fees. Everybody doesn't want to pay attorney's fees. It is a big deterrent for either side to file an actual lawsuit. This is a powerful provision and it influences the course of a lot of disputes. if the demanding party, that's somebody who's complaining about something, knows that there's a risk of owing attorney's fees if they're wrong, it can temper even the most lawsuit happy client. On the other hand, if you're an innocent party who hasn't done anything wrong, you want to be able to defend yourself and hire an attorney knowing that in the end, when you're vindicated, the other side will be forced to pay your attorney's fees. Again, it really just protects both parties and can work towards a resolution instead of filing a lawsuit and both sides paying a lot of lawyers' fees without any resolution. Finally, thanks for watching. I hope this was a helpful guide with some very important clauses to put in your next commercial or subcontractor, general contractor agreement, whether you're doing a GMAX or you're doing a cost plus. These are very important to specify, and they can be even a casual handwritten agreement. Just put them in there and know what they mean. Smash that like button and subscribe if you like the content. Until next time.